Hi, my name is Mark Monlux, and you're watching another episode of Law and Artist. I'm a freelance illustrator that lives in Tacoma, Washington. And for the last couple of decades, I've been good friends and buddies with my friend Daniel Abram, who lives over. Daniel, where do you live?
Brooklyn, New York. Garden spot of the world. In any case, Mark and I have been discussing legal issues for a very long time. It is always a pleasure to do so, and it is a pleasure to do so for a greater audience here.
Now, before we get into today's topic, I'm going to throw up our disclaimer. Would the audience please be so kind as to stop your monitor, read this disclaimer, and understand that we have to do this for legal, political, hogwash reasons. Now, Daniel, we've been talking a lot about copyright law, but I want to switch over the focus to some other interesting sections of law, particularly the right of publicity and the right of privacy. These are sort of like two sides of the same coin. Can you give us a definition?
Well, right of privacy basically means you own your own likeness. You have the right to control where your likeness appears. It means I cannot take your likeness, slap it on my bag of flour and say Mark Monlux endorses this flour because, without your permission for me to do so. Right, that's partly right of publicity because, we're talking about a commercial usage. It's also right of privacy because you have the right to the private ownership of your own likeness. Right of privacy, right of publicity is a weird thing because unlike copyright, unlike trademark, both of which are controlled largely by national laws, by federal laws, they vary from state to state. And this means that in New York, for example, right of privacy, right of publicity exists while you're alive. Drop dead, and the entire right ceases. If you go to California, however, where they've got more celebrities than you can shake a stick at, they have a right of privacy, right of publicity that lasts for 70 years after your death.
Oh, I remember this case where an artist put the Three Stooges up on a T-shirt, and the heirs went after him and won the case.
That's exactly correct. According to the California law, it's a statutory law. According to the California law, if he had kept this to 200 or less than 200 images in a limited edition print, he would have been fine. But he put them on mass market T-shirts, and this was considered to be something which was in violation of the California right of privacy, right of publicity law. Similarly, some people may remember the ad a few years ago where Fred Astaire was dancing up and down the stairs with a vacuum cleaner in his hand. They'd photoshopped this in. And this was also a violation of the right of privacy, right of publicity law because Fred Astaire, although dead, had not endorsed this vacuum cleaner. Now, this is something you have to be careful of, primarily because it shows up in the warranty clause, which is always the minefield for every artist. When you're signing a major contract, the warranty clause, which shows what you're responsible for, will often include right of privacy, right of publicity. Watch for this and make sure that you're not committing to something you don't want to commit to.
It's always good to ask whatever model or whatever photographic resource you're using, to ask first to get the permission to use that image or to have waivers when you're taking your own photos. For example, I'm going to be doing a drawing group next week, and we're going to have a bunch of cosplayers there. We're going to have the cosplayers sign a waiver saying that these images will be used by these artists for possible other means. It's a thorough way to protect yourself. If someone took a photograph of that cosplayer and then later did an illustration of it, there's a window there without written permission.
Excellent point. Excellent point. Releases are the artist's friend. Releases are your armor against nasty complications later.
I think we touched on a really interesting subject, and I'd like to come back to it, but we've run out of time for this episode. Please follow us again when myself and Daniel come back and talk about other questions.
Thank you, Mark. It's always a pleasure.
Hopefully it can be less verbose at the end of the next one. Thank you again.
There you go.